As a nation, Scotland is gifted with majestic mountains and lochs, alluring islands and vibrant cities. It's a land of ancient castles and modern infrastructure, with a proud history and a rich culture. And in surveys, Scotland has been voted the most beautiful country in the world. Yet for all of this, Scotland is nowhere near as well known as it should be. Scotland may be a beautiful nation, it may be a culturally rich and vibrant nation, yet it is not an independent nation. And the everyday reality of this means that it does not have the same level of international recognition that similarly sized and smaller independent nations enjoy. As part of the United Kingdom, Scotland lives in the shadow of its larger neighbour England. The situation is further compounded by the fact that England and the United Kingdom are, to the world at large, largely synonymous. Because of this, international recognition of England as a name and a brand remains strong. The same cannot be said for Scotland, however. A traveller from Scotland will time and time again find him or herself having to explain to all and sundry that no, Scotland isn't just a part of England, and no, they are not English. It all becomes so tiresome. So why are things this way? Why, after 3 centuries of union, does England continue to be widely known internationally, whereas Scotland is not? After all, England is a part of the United Kingdom, just as Scotland is. Well, firstly, with a population of 56.2 million, England currently has over 10 times the number of people that Scotland has. And secondly, Great Britain was never truly designed to be a separate and distinct entity from England. The British state was, from day one, essentially an English state. Take for example the Houses of Parliament and their historic traditions. The Westminster Parliament that you see today is essentially the same Parliament that started life in 1295, over 400 years before the Treaty of Union. Its historic traditions and procedures date from long before 1707. For example, the tradition that each sitting of the House begins with prayers, well, that can be traced back as long ago as 1558. Or take Black Rod, the usher who summons the House of Commons to the state opening of Parliament. Well, this post dates from as far back as 1522, with the office itself dating back to 1350. When the supposedly new Parliament came into being in May 1707, it was not even considered necessary to hold a new general election. This was despite the fact that the electoral map of Scotland had been substantially redrawn. Furthermore, although Scotland's population at the time was 20% the size of England's, it was only awarded 45 MPs, compared with England's 513. Essentially, there were so few Scots in Westminster that they were barely noticeable, and England's Parliament simply continued on as if little had changed. International treaties that had been concluded by England prior to the Union were considered to remain binding, whereas those signed by Scotland were not. The Anglo-Portuguese Treaty of 1373, for example, is still in force today, and is in fact the oldest active treaty in the world. And even to this day, the United Kingdom's international agreements with other states are prefixed Anglo. Under the Treaty of Union, it was specified that Scotland would harmonise with England, and not vice versa. Scotland had to adopt England's laws in a whole raft of areas, including the regulation of trade, customs and excise, coinage and weights and measures. The reality of this newly created state of Great Britain meant little in England. Its capital city continued to be the hub of political and economic decisions, and furthermore, it remained the home of its head of state. Great Britain was not so much a new state as it was the continuance of the English state with a nameplate change. In the House of Commons in 1889, Dr. Gavin Clark, Liberal MP for Caithness, noted the following during his motion calling for Scottish Home Rule. An attempt is made here to ignore Scotch nationality. We hear of the English government and the minister is not called to order for the expression. Why, only the other day the Secretary of War spoke of the English troops he was sending to Egypt, the Scottish borderers. As the old expression goes, the more things change, the more they stay the same. In truth, a lot has actually changed since 1707. There are now parliaments in Scotland and Wales, and an assembly in Northern Ireland. Yet devolution also serves to highlight that the UK is a faux union. There is no English devolved parliament, save that of Westminster. Nor is there a Secretary of State for England in the same way as there are Secretaries of State for Scotland, Wales and Northern Ireland. There are also inequalities among the devolved nations themselves. Whilst Wales's Parliament is broadly similar in scope to Scotland's, it is Northern Ireland's Assembly that is the most powerful. It has its own civil service. It is 3 times the powers that Scotland has, and it gets to remain in the European single market. It is the legal right to choose its own constitutional destiny enshrined by international treaty, and the right to hold a referendum every 7 years after the first one. Yet it is England's constitutional position that truly stands apart from that of Scotland, Wales and Northern Ireland. Sure, it doesn't have a devolved parliament, yet it doesn't need a devolved parliament. Westminster is its parliament. It always has been. It's been around for over 700 years and has thus spent less than half of its existence as the Parliament of the United Kingdom. And with 86% of MPs in Westminster being English MPs, what England wants, England gets. On closer inspection, England appears to be something of a colonising nation, with Scotland, Wales and Northern Ireland being its colonies. When attempting to determine Scotland's constitutional status within the UK, the first thing to consider is that the UK has no constitution, at least not in the sense of having a specific codified document. Certainly, there are a loose collection of statutes, laws and precedents that are claimed by constitutional experts to amount to a constitution, yet there is no written document. So, without a written constitution, where exactly does sovereignty lie? Well, if the UK Constitution is claimed to be defined by its laws and statutes, then one would naturally assume that sovereignty would have been established by the laws and statutes published by Westminster. Yet when you search for the term sovereignty in the records of the National Archives, under the parameter all UK legislation, excluding originating from the EU, the only listed results relate to 3 acts from the pre-1707 Scottish Parliament. The simple fact is this: there is no act of the Westminster Parliament relating to the matter of sovereignty, nor is there anything in the Treaty of Union or in the subsequent Acts of Union. Constitution experts will of course assert that sovereignty in the UK is not about laws or statutes or even the Constitution. They'll tell you that sovereignty is all about legal precedents and the notion that Westminster's parliamentary sovereignty holds sway. And indeed, if you search the records of the Supreme Court, the UK's highest court, there are numerous references and rulings with regard to sovereignty. In one such judgment, in the UK Withdrawal from the European Union Legal Continuity Scotland Bill, it refers to Section 28 of the Scotland Act and states that notwithstanding the conferral of legislative authority on the Scottish Parliament, the UK Parliament remains sovereign. There are 2 key factors to take into account here. Firstly, and importantly, sovereignty is not actually mentioned in the Scotland Act. Secondly, the Scotland Act was created by the UK Parliament, the very body that may not actually be sovereign, at least in relation to Scotland. And there are court cases that suggest that this could be the case. For example, during the constitutional case of McCormick v Lord Advocate, held in the Court of Session in 1953, Lord President Cooper stated that the principle of unlimited sovereignty of Parliament is a distinctly English principle which has no counterpart in Scottish constitutional law. In some respects, the issue of sovereignty has become something of a vicious circle. Here's how it works. Westminster, acting as a sovereign body, creates the Scottish Parliament and decrees it to be subordinate. Then Westminster creates the Supreme Court to its own specifications. The Supreme Court in turn rules that, due to a previous act passed by the Westminster Parliament, Westminster is the sovereign legislator of Scotland. Therefore, in the eyes of the law, the UK Parliament simply acts as a sovereign body, and the precedence it sets in doing so makes it sovereign, according to court rulings. Yet if this is the case, then why can't the Scottish Parliament similarly set its own precedents by acting in a sovereign manner? In 1988, a document called A Claim of Right for Scotland was produced by the Campaign for a Scottish Assembly. It stated the sovereign right of the Scottish people to determine the form of government best suited to its needs. The document was signed by all of Scotland's then serving Liberal Democrat MPs, and all Labour MPs bar one. It included the signatories of a future Prime Minister Gordon Brown, a future Chancellor of the Exchequer Alistair Darling, and two leaders of the Liberal Democrats, namely Charles Kennedy and Mingus Campbell. Noteworthy is the fact that the Scottish National Party didn't sign it, and the reason for this is that whilst the claim asserted the sovereign right of Scotland to choose its own form of government, it was under the somewhat contradictory precondition that the government itself wouldn't be sovereign. Of course, at that time, Scotland was a predominantly unionist voting country, and as such, the Campaign for a Scottish Assembly was a product of the political landscape at that time. Yet over 3 decades have now passed since the claim was signed, and both the political landscape and the public mood have been completely transformed in Scotland. The idea today that Scotland should have the sovereign right to choose its own government, but not a sovereign government in itself, now seems patently ridiculous. So why did Scotland really give up its statehood? Well, the version of history that you've heard probably goes something like this. Following the failure of the Darien scheme to successfully establish a colony in Panama during the late 17th century, Scotland was essentially a bankrupt nation. Luckily, England stepped into the fray and rather generously agreed to bail Scotland out, albeit with a few terms and conditions of course, including abolishing its parliament and submitting to London rule, all standard practice. Nothing out of the ordinary. No. The reality is actually rather more nuanced. Firstly, while the Darien scheme had attracted thousands of ordinary Scottish citizens to invest a huge proportion of the nation's available capital, it had largely been privately funded. Thus, whilst the collapse of the scheme had proved to be a huge financial blow to the nation, it had largely affected the people of Scotland rather than the state itself. Thus, while Scotland had a national debt of only £160,000, England by comparison had a national debt of £18 million. The collapse of the Darien scheme was certainly a factor in Scotland's decision to sign the Treaty of Union, but it was not the only factor. Indeed, in many respects, it was merely the straw that broke the camel's back. In the 5 decades prior to 1707, England passed a series of acts that had a devastating effect on its relations with Scotland. These acts harmed not just Anglo-Scottish trade and Anglo-Scottish interests, but even the Union of Crowns itself. It all started with the English Navigation Acts of 1660 and 1663, which classified Scotland as a foreign country and thereby excluded Scottish ships from trade with the English colonies. These 2 acts were a key factor in the failure of the Darien scheme. Then, in 1701, England passed the Act of Settlement in response to the failure of Queen Anne to produce any surviving children. It was decreed by England that the crown would pass to the German House of Hanover before Anne's death. Scotland, however, had not been consulted, and in response passed the Act of Security in 1704, ensuring that it reserved the right to choose its own successor to Queen Anne. The Union of Crowns had essentially come to an end. Yet alienating Scotland on the high seas and driving a coach and horses through the Union of Crowns was not enough in itself to force Scotland to abandon its statehood. What was needed was a much firmer push, a move that would force it to submit to political union with England. This materialised in the form of the Alien Act of 1705, which led to an embargo on Scottish products being imported into England and its colonies, and curtailed exports from England and its colonies to Scotland. Further provisions in the Act classified Scots living in England as being aliens. in other words, foreign nationals, and asserted that estates held by Scots would be treated as alien property, something that made inheritance uncertain. Looking through the lens of history, it's clear to see that England had engineered the dismantling of the Union of Crowns and had systematically alienated its closest ally with the aim of forcing it to submit to a political union. This was not two states voluntarily coming together for the betterment of both. Rather, it was a larger state forcing its smaller neighbour to submit to a political union for its own benefit. It was, in short, a takeover, not a merger. International law states that nothing can be done without or against the will of a sovereign state. With this in mind, it is worth recapping that England, the nation calling for political union with Scotland, had in the years leading up to 1707 implemented the following measures against Scotland. Decreed that Scottish ships were to be considered foreign and forbidden from trading with England's colonies. Blocked all imports from Scotland, resulting in Scotland losing half of its export market. Curtailed many exports from England to Scotland. Unilaterally passing legislation relating to the monarchy despite being in a union of crowns with Scotland. Reclassifying Scottish citizens and their property in England as alien, removing in the process many of the rights they previously enjoyed. Let's also keep in mind that the above measures were implemented by a country that had shared a monarch with Scotland since 1603 and was supposedly an ally of Scotland. Things of course were done differently in the past, and the point here is not to question the validity of the treaty. Yet that does not stop us from asking whether, given the circumstances under which it was signed, Scotland should have the right to revoke the treaty, or at least redraft the treaty on equitable terms. Nowadays, the concept of sovereign equality of states is a foundational principle in international law. States are deemed equal just by their status as states. States therefore are considered equal regardless of their geographical size, their population size, the size of their economy, their military power, or their level of industrialisation. So for example, a tiny state like Luxembourg is considered an equal under international law to the United States. This is of course an example of modern international law, and whilst it would be hard to argue that Scotland and England were equal signatories of the Treaty of Union, we have to accept that it was signed in a time when smaller nations did not have the protections that are available today. The Permanent Court of Arbitration, for example, came into being almost 2 centuries after the Union in 1899, whilst the International Court of Justice was founded even later in 1945. Nonetheless, we live in a society today that is willing to try and right the wrongs of the past. Take slavery, for example, which was commonplace at the time the Treaty of Union was signed. These days, many historical statues and symbols associated with slavery have been removed worldwide. Scotland should at least have the right to have its historical wrongs rectified. And if this union is to try and claim to be in any way fair, then Scotland should have the right to revoke the treaty if it so chooses, especially given the circumstances under which it was signed. After all, if England wanted to leave the Union, or perhaps more accurately, dismantle it, who could stop it? Neither Scotland, Wales or Northern Ireland, whether separately or combined, could prevent England from leaving the United Kingdom. Yet whilst England is free to decide its own destiny and that of the Union, Scotland is essentially little more than a hostage of England's greater population. And when English politicians who've neither lived nor worked in Scotland continually dismiss Scotland's right to choose its own constitutional destiny, it shows just how insecure they are about the union they are forcibly trying to hold together. It could be argued that the Scottish independence referendum of 2014 was a de facto vote for the Union. The reality, however, is that from the get-go, the cards were stacked almost entirely in favour of the Union. Firstly, at the time of the referendum, Scotland had already been subjected to over 300 years of UK state propaganda. For 3 centuries, the British state has been able to promote its case to exist It's raison d'etre, if you will, without impediment or restriction. And while Scotland may now have its own parliament, it is still very much restricted within the devolution framework. Broadcasting in Scotland, for example, is entirely under UK government control, and almost every newspaper sold in Scotland is published by an English-owned pro-union media company. During the 2014 referendum, having almost complete control of the mainstream media was a major weapon in the British state's arsenal, and was used to great effect to stoke up fear over the likes of jobs and pensions should Scotland have chosen independence. The only media source where independent supporters were given a fair crack of the whip was in the realm of social media, in particular Twitter and Facebook. Taking everything into account, the fact that the pro-independent side achieved 45% of the vote is nothing short of remarkable, especially given that it had started from a support base of less than 30%. Moreover, it would be entirely logical to assume that of the 55% who voted no, a great many did so out of fear rather than a love of the UK. Fear for their jobs, pensions, economic well-being and the potential loss of EU membership, rather than any genuine love for the British state. Whichever way you look at it, the 2014 vote was hardly a ringing endorsement of the Union. There are those who would argue that federalism offers Scotland the best of both worlds. Not only could it address the imbalances of the current United Kingdom, it could also deliver Scotland a greater level of autonomy without the need to leave the Union. Never mind that for a century and a half the British government have been promising federalism in one form or another and have never delivered it. The simple fact of the matter is that the British state has absolutely no intention of ever implementing a federal UK. And the reason for this is simple. To be in any way workable, it would likely require the breakup of England. Why? Well, because England is simply too big population-wise compared to Scotland, Wales and Northern Ireland. It would make the federal union too lopsided to be successful. Take Germany for example. It can exist successfully as a federal state, yet it was only made possible by the dismantling of its largest constituent part, Prussia. Yet the United Kingdom exists primarily to benefit England, not to extinguish it or to threaten its constitutional integrity in any way. The creation of a federal UK would therefore be highly unlikely to ever happen, and even if federalism could be delivered, it would still ultimately fail to deliver key powers that Scotland needs to become a modern progressive nation. For example, there would be no citizenship, no elected head of state, no international identity, no seat at the UN, no membership of the EU, no foreign policy, and a good chance of getting dragged into wars that it had no desire to participate in. It is said that a Section 30 order is required for Scotland to have a legally binding referendum. But why? And what is Section 30 anyway? Section 30 of the Scotland Act relates to the temporary transferring of reserved powers to Scotland from the United Kingdom, and it must be approved by the Scottish Parliament and both houses of the UK Parliament. Yet the issue of a Section 30 order is not directly concerned with referendums, or with sovereignty. Rather, it relates to the Union, because the Union is a reserved power. However, during the 2014 independence referendum, the UK government employed the services of two academics, Professors James Crawford and Alan Boyle, to assess the constitutional aspects of independence. In their findings they wrote, whether or not England was also extinguished by the Union, Scotland certainly was extinguished as a matter of international law, by merger either into an enlarged and renamed England, or into an entirely new state. It may also be misleading to speak of dissolving the Union. In international law, the position of the UK does not necessarily differ from that of a state formed in some way other than by a union. Crawford and Boyle on behalf of the UK government are essentially stating that firstly, the UK is little more than a rebranded, enlarged England. Secondly, that the Union exists only as a historical event rather than an existing entity, because under international law, they consider the UK's position to be no different from any other state. Some unionist bloggers have tried to make a similar argument. The argument is, if the Treaty of Union had extinguished Scotland, then the Union would only exist as a one-time historical event, not a continuing entity. However, given that the Union, as an entity, has been reserved by Westminster, then logically it must still exist as a living entity. Put simply, you can't reserve something that no longer exists. Moreover, if the Union is still in force, then the treaty that created it must likewise still be in force. Yet if Scotland cannot leave the Union of its own volition, then the United Kingdom is not actually working as a union, and by reserving power over the Union itself, Westminster has effectively placed it solely in English hands due to England's larger population and the fact that its MPs can always outvote Scotland's. The creation of the British state was brought about by England for its own benefit. It was not some mutual coming together of two states for the benefit of both. It wasn't Scotland, after all, that introduced the Navigation Acts of 1660 and 63, or the Alien Act of 1705, and nor was it England's Parliament that was abolished in 1707. It was Scotland's. For England, the Union was never about abandoning its statehood, as had been the case in Scotland. Rather, they saw it as expanding and enhancing their state through the acquisition of Scotland. Not only did the Union leave it with almost full control of its neighbour, it also provided them with additional land and resources, as well as an enlarged consumer market. It was in essence the ultimate expression of English nationalism. And if England intended the British state to be, in the words of Professors James Crawford and Alan Boyle, an enlarged and renamed England, then this is perhaps the reason why they chose not to define it constitutionally. A written constitution would have cemented in place the fact that the British state was a separate, clearly defined entity from the Kingdom of England that preceded it. Yet this was really about renaming the English state rather than superseding it. And if England considered the British state to be in essence a continuing English state, then naturally they would have expected the notion of parliamentary sovereignty to be inherited by the British state. Yet the idea that parliamentary sovereignty can simply be cemented in place through precedents is moot if the Parliament was never sovereign to begin with. And the use of precedents, or more specifically binding precedents, to declare parliamentary sovereignty over Scotland is contrary to Scottish law, a law protected by the Treaty of Union itself. Moreover, it is also out with the spirit of the treaty, which made no demand on Scotland to transfer its sovereignty. Furthermore, if legal precedent is considered of such importance in determining Scotland's constitutional rights within the UK, then surely the referendum of 2014 has already set the precedent for the holding of a future referendum. And let's be clear, throwaway remarks at the time of it being a once-in-a-generation vote were just that, throwaway remarks. There is absolutely nothing in writing that binds Scotland to being only permitted to hold a referendum just once in a generation. Indeed, the sheer vagueness of the term generation is indicative of this alone. For example, with regard to Northern Ireland, it is stated in the Belfast Agreement that a referendum on Irish unity can be held specifically 7 years after a preceding referendum. No similar requirement exists in Scotland. When politicians in London, politicians, let's be clear, who have never lived or worked in Scotland, choose to ignore or simply brush aside Scotland's right to determine its own constitutional destiny, they serve only to highlight the fact that Scotland is not part of a real union. Rather, the United Kingdom is a faux union, with decisions being made by England and England alone. Ultimately, Scotland's right to choose is being held hostage by a population imbalance that works entirely in England's favour. And we should ignore every false promise of federalism. As we have seen, federalism is highly unlikely to ever happen, and even if it did, it would fail to provide Scotland with many of the powers that similarly sized independent nations have. If the UK was in any way serious about being a British state rather than an English state, then it would cease the practice of prefixing its international agreements and treaties with the word Anglo. Likewise, the Bank of England, the UK's central bank, could easily be renamed the Bank of the UK, or the Bank of the United Kingdom. These are two very small steps that could easily be taken in order to make the UK at least appear more like the union it purports to be. That there have been no serious moves to take these steps is somewhat indicative of the true nature of the Union as a fundamentally English state. In every respect, England is the glaring anomaly in the Union. There is no Secretary of State for England. There is no England Act, like there is a Scotland Act, a Wales Act and a Northern Ireland Act. Its parliament was never abolished. It has 86% of all MPs, meaning it pretty much gets what it wants. So whilst England can prevent Scotland leaving the UK, Scotland can't do likewise for England. The upshot of all of this is that the United Kingdom is a very unbalanced union, favouring its most populous nation at the expense of its smaller nations. Essentially, the UK is not behaving as a union in any real sense, but rather as an English state with Scotland, Wales and Northern Ireland being at best appendages, and at worst little more than colonial outposts. Forcing Scotland to remain in such an unbalanced union is both unjust and undemocratic, and every avenue must be explored to challenge this state of affairs and to reclaim its right to choose its own constitutional destiny. So what now? Well, the first issue that needs addressing is whether a Section 30 order must be obtained in order to hold a legally binding referendum. Certainly, the UK government could simply grant a Section 30 order, yet so far it has refused to do so, and is very unlikely to do so in the near future. Moreover, even if it were to grant a Section 30 order, it's likely that it would only be issued alongside a whole raft of terms and conditions favourable to the Union. The next logical step therefore would be to challenge in a court of law whether a Section 30 order is a legal requirement in order to conduct a binding referendum. As we have seen, Section 30 relates not to referendums but to the Union itself. Yet if the Union is not working as a union, and can be demonstrably shown not to be working, then this may work in Scotland's favour in a court of law. Moreover, as we have seen, both the issue of where sovereignty resides and the constitutional status of Scotland, and indeed the UK itself, have never been adequately defined and remain open to interpretation. In the event that a legal challenge for the necessity for a Section 30 order is rejected in court, then the next step should be for Scotland to prepare to hold a referendum regardless. Much of the preparation for this should also include developing a close relationship with the European Union, so that in the event of a vote in favour of independence, Scotland will potentially have recognition already in place to support its subsequent declaration of independence. Developing such a relationship with the EU should be a relatively easy process. Firstly, Scotland is a predominantly pro-EU nation, and as such stands in stark contrast to the UK state, which is somewhat out of favour in Europe, with trust issues at an all-time low. Secondly, the EU would likely jump at the chance to regain a pro-European part of the UK back into the club. Another aspect that could work in Scotland's favour in garnering support from the EU is the fact that whilst the English judicial system is a common law system, most nations in the EU have civil law. In other words, they have codified judicial systems. A simplistic way of looking at it would be this. Civil law essentially details what you can do and how you must do it. Common law, however, focuses on what you cannot do. The fact that the UK has neither a codified constitution nor chosen to define where sovereignty lies within the different jurisdictions of the state would likely be considered alien by most nations in the EU, where codified constitutions are the norm. And were Scotland to vote for independence, and the UK state chose not to recognise this vote, then these factors may well work in Scotland's favour in helping it to win support and recognition for its independence from outside the UK. The key to any nation's independence comes first and foremost from international recognition. Without this, any independence bid will fail. If the UK state were simply to support Scotland's right to be independent, then this would be an easy process. Yet the UK is currently in the grip of a right-wing English nationalist government, with absolutely no intention of letting Scotland go. Scotland needs to recognise this reality and instead focus its energies on developing relations internationally. Because its greatest battle in becoming an independent nation may not be with the UK state, but in achieving international recognition for its independence.